Hello, my name is Mike Connors. I'm the attorney who started Connors & Sullivan almost 40 years ago. We're a law firm that does estate planning and elder law. The idea behind estate planning is to pass assets from one generation to the next, paying the least amount in taxes that we need legally to pay, avoiding going through court, avoiding probate, and as far as elder law is concerned, trying to protect assets from nursing home bills. Now, we have 5 offices in the New York area. Our main office is in Bay Ridge, Brooklyn. We have branch offices in Midtown Manhattan, Staten Island, Bayside, Queens, Middle Village, Queens. If you'd like to schedule an appointment with our office, we do not charge for the initial consultation. The first consultation is free on anything that we're talking about in this seminar. We do not charge for the first meeting. The first meeting is free, then we take it from there. Everything we do as far as estate planning and elder law is on a flat fee basis. You come in, we give you an estimate, you know how much it would cost, and then you take it from there. There are 3 basic estate planning tools that pretty much everybody should have: will, power of attorney, healthcare proxy. What's a will? A will is a writing witnessed by 2 people that disposes of assets in your name alone. It appoints an executor. The executor is the person you choose to wrap up your legal, financial, business matters after you pass away. That's one reason everybody should have a will. You want somebody in charge. You don't want chaos. The person in charge is an executor. 95% of the time, the executor is going to be a family member: spouse, son, daughter, trusted nephew or niece. Doesn't necessarily have to be. And for the sake of argument, if you leave everything to charity, maybe you want somebody else to be an executor. But everybody should have an executor if for no other reason you want somebody in charge. But as important as a will is, it's a very limited document. We're going to be talking about the limitations of a will. And one of the limitations of a will, it has no effect when you're alive. So let's say, for the sake of argument, you have a stroke or another disabling illness. You can't manage your affairs properly. A will does no good. What do we use? The document we use in that case is a power of attorney, a durable power of attorney. One that's effective. God forbid you have a stroke or a disabling illness. You could put somebody in charge. Again, 95% of the time it's going to be a family member, in order to pay your bills, protect your assets. God forbid you have a stroke or another disabling illness. A very powerful document. We're going to be talking more about it later. Now, don't confuse a will with a healthcare proxy. A healthcare proxy is a document witnessed by 2 people where you can appoint somebody as an agent to make medical decisions on your behalf if you can't speak for yourself. So, a healthcare proxy, you appoint somebody to make medical decisions on your behalf if you can't speak for yourself. And again, you may want to think about a living will. A living will is not a legally recognized document, but it gives direction to your person making decisions. If I have a terminal illness, I don't want to be resuscitated. If I want to live my last days of my life at home, not in a nursing home. It's not legally binding, but it's there as a direction for your relatives to make decisions on your behalf if you can't speak for yourself. Now, getting back to the will. Again, everybody should have a will. It's a very important document, but as I mentioned before, there are limitations in the will. And one of the biggest limitations of a will, it's not automatic. A lot of people think, I have a will. I leave my house to my nephew and niece. They can sell the house a few days after I'm gone because my will is clear. And why should there be any delay? It doesn't work that way. A will is not valid to transfer assets until a judge says it's valid. That's the court proceeding called probate. And ordinarily, we don't want our relatives to have to go to court. We want to avoid probate. And that's what we're going to be talking about, the problems with probate. If when you pass away, there are assets in your name alone, those assets pass through court. If you have a will, they go through probate. If you don't have a will, they go through court administration. You're always better off with a will because you want to, if nothing else, choose the person to be in charge. But if you pass away with assets in your name alone when you die, those assets go through court. Now, some people think, well, I don't have to go through probate or court. I don't have enough assets to be taxed by the government. Well, it doesn't quite work that way. If you have more than $50,000 in your name alone, you're going to go through probate. And sometimes it's a simple procedure, but there's always some kind of problem with probate. It is a court proceeding. There's always some delay. Ordinarily, we want to avoid probate. You don't want your family, your friends, your relatives to have to go through court. Why do you want them to go through court? And here's some of the problems with probate. If somebody's going to contest your will, probate takes forever. So I'm going to give a number of stories, and I always use the name Smith just to make it easy on myself. So we have Mrs. Smith. She has 3 children. 2 children are working hard, and they're going into debt trying to send their kids through college. We have a 3rd child, a son. His name is Jack. Jack's got a problem with drugs and alcohol. Jack has a criminal record. Jack hasn't worked a hard day in his life. Jack gets fired from one job or another. His mother takes him in. He eats her out of house and home. He doesn't contribute. So now it's time for Mrs. Smith to do her will. And she says to herself, you know, my main asset is my house. It's worth $900,000. I'm going to leave my house to my 2 children who've been working hard. It's only fair because over the years, Jack has drained hundreds of thousands of dollars from me. I'm just evening things up. And not only that, if I left Jack a third of my house, he'd blow it on drugs anyway. It wouldn't even do him any good, might kill him. At least my other 2 children, they'll sell the house, they can pay off their kids' student loans, they can pay off their mortgages, use it for their retirement. And as I said, it's only fair because Jack has drained so much money from me over the years. Now, he's still my son. I'll leave him $25,000. So Mrs. Smith goes to a general practice lawyer. She does a will. I leave $25,000 to Jack. I leave everything else, including my house, to my other 2 children. Mrs. Smith dies. The deed to the house is in her name alone when she dies. The 2 children that have left the house, obviously they want to sell it. But the deed is in Mrs. Smith's name alone when she passed away. So they can't sell it without going to court, without going to probate. Part of the probate proceeding, everybody officially gets a copy of the will and is entitled to file objections to contest the will. That's the law in New York State, no exceptions. Jack gets a copy of the will. Jack goes to a lawyer. Jack knows lawyers. He's been arrested a few times. So he goes to one of the lawyers who got him off once, and he says, hey, you know, my mother has a $900,000 house in Queens. She's got a couple of $100,000 in the bank. I'm getting $25,000 of well over $1 million. What can we do about it? The lawyer says, sign here. Objections to probate. One of the objections to probate, my mother was forced to sign the will against her wishes. That goes to court. This is a lawsuit, a contested matter. And those of you who've been involved in lawsuits, you know it seems like nothing happens for months. The case just kind of like sits there. Now eventually it gets assigned to a referee in the surrogates court. The job of the referee is to settle cases. What settles cases? Money. So the question gets asked, how much money is it going to take to settle this case? Not necessarily the full history of the case, but how much money? The 2 children who left the house, they stand on principle. Wait a minute, why did her mother write a will? She said $25,000. That's it. And the referee still wants to settle the case. He exerts pressure on the parties. And one of the ways sometimes they exert pressure on the parties is through delay, hoping one side or the other will eventually give in. And why does the court do that? Because if the case goes to trial, the truth doesn't always win. Jack has a girlfriend. Jack and his girlfriend come up with a story. It goes a little bit like this. Jack's girlfriend gets up on the stand and she says, I knew Mrs. Smith very well. My friend Jack, he quit his job to take care of his sick mother. The truth was he was fired from his job and was freeloading off his mother. But facts change when people die. I can't tell you how much I've seen that happen. So she goes on to say, well, one day I was visiting, Mrs. Smith was at the breakfast table, and she was crying. And I said, what's the matter? She said, you know I love Jack. I want to leave Jack my house. But my daughter found out about it, and she hit the roof. And she started yelling and screaming. And she said that if I left Jack the house, she was going to have me declared incompetent and throw me in a nursing home. Then she dragged me to her lawyer. They made me sign a will. I didn't want to sign it. And she said if I ever changed it, she was going to throw me in that nursing home. And Mrs. Smith started crying. I didn't want to sign that will. All right. Jury, here's that story, 3 o'clock on a Friday afternoon. Those of you on jury duty, what happens? You flip a coin. You want to go home. If you don't want your estate to be decided by a jury, you want to avoid probate. You avoid probate when you pass away. There are no assets in your name alone. And we'll tell you how to get there before we're finished. Now, who can contest your will? Well, if you don't have a will, the state of New York writes a will for you. And the people that are named in that will, your next of kin by law, in effect. And everybody has a will, whether you know it or not. You either have a will that you signed or you have a will that's written to you by the state. So anybody who's your next of kin by law is entitled to file objections to contest your will. If you're married, obviously your spouse can contest your will. In addition, your spouse can put a claim in against your estate. It's almost impossible to disinherit a spouse in New York unless they signed a prenuptial agreement or a waiver or something like that. Sometimes even separated spouses. Now, assuming you, and if you have children, any one of your children can contest the will. And let's say we have a husband and wife. Husband leaves everything to his wife. He has a business in his name alone. He dies, that business is in his name alone. Wife wants to sell the business. You have to go through probate. One of the children contests the will. You might say, how could that happen? Why would that happen? Second marriage, spite, but even between husband and wife, we want to avoid probate. You avoid probate again. When you pass away, there are no assets in your name alone when you pass away. Now, assuming you have no wife, you have no children, no grandchildren, because if one of your children passes away, their children, grandchildren step into their shoes. If you have no children, grandchildren, you're not married, your next of kin by law will be your parents or the survivor of your parents. And sometimes that causes problems. A few years back, we had a lady passed away. She was 87 years of age. She left everything to her mother. Mother was 104. And that was a good plan because mom went to a nursing home. A lot of the daughter's life savings went to pay for mom's nursing home bill. We could have had a better plan in place. People don't always die in the right order. You never know what's going to happen in this world. Now, assuming your parents are gone, you have no children or grandchildren, you're not married, your next of kin by law would be your brothers and sisters. If one of your brothers and sisters passes away, their children, nephews and nieces step into their shoes. Now, in New York, a half-brother or sister is considered the same as a full brother or sister, and the children of a half-brother or sister considered the same as a nephew or niece from a full-blooded brother or sister. So some people get confused on that. Now, if you have no nephews and nieces or closer relatives, your next of kin by law are descendants of your grandparents. Uncle, aunt, first cousin once removed. If you do not have descendants of your grandparents alive, you're not married, your next of kin by law is New York State. And if you had assets in your name alone in that case, those assets would pass to the state. And it happens a little bit more than you might think. We got a husband and wife. They have no children. Husband had a number of brothers and sisters. They've all passed on. He's got 6 nephews and nieces. He's close to them. They're close to his wife. They call her aunt. The wife, will say in this case, is an only child. Her mother, now deceased, was an only child. Her father, now deceased, was an only child. The couple owns a house together. They don't have a will because they think everything is joint. Something happens to husband, everything goes to wife. Something happens to wife, everything goes to husband. The survivor can always do a will. They're driving one day. They're in a car accident. Husband's pronounced dead at the scene. Wife goes to the hospital. She lingers on for a few days. She dies. They never did a will. Who owns the house? New York State. Why? When the husband died, he left everything to his wife. When the wife died, again, in the fact pattern I gave, she does not have any relatives descended from her grandparents. So the assets in her name alone pass to the state. The house goes to the state. What about the husband's nephews and nieces? Well, your spouse's relatives are not your relatives by New York law. So since the husband died first and the wife lingered for a few days, all the assets that they had joint went to the state. Everybody should have a will. You need to plan things out. I mean, the example I just gave, does it happen often? No, it happens. But I can tell you what happens very often. Husband gets sick, dies of natural causes. Wife's upset. She doesn't get her affairs in order. Next thing you know, we've got a problem. And that's happening more and more. COVID, I used to say husband and wives usually don't die together at the same time. But now with COVID, we see a husband dies one day, wife dies a few days later without being prepared. Everybody should have a will. That's your starting point for estate planning. I'm going to give a story now about another lady who didn't think she needed a will. And the reason she didn't think she needed a will, she didn't have any assets. And I hear that all the time. I don't need a will because I don't own anything. Well, this woman didn't own anything. She was on SSI. For those of you who know SSI, she collected about $600 a month in Social Security payments, food stamps, Medicaid. She had no more than $2,000 in the bank. And her bank account was joint with her best friend. So why did she need a will? That's everything she owned. She had nothing else. Now, her best friend would, take her out to lunch every week, make sure she had a place to stay for the holidays. Not that the woman on SSI didn't have a family, she had a sister. But the woman on SSI was physically disfigured. And the sister wanted nothing to do with her. She disowned her from when they were kids. Now the woman on SSI, she lived in what we used to call a welfare hotel. She didn't even own the furniture in the hotel room. So again, why did she need a will? Except there was a fire in this hotel. The woman on SSI died in the fire. Lawsuits were brought. The friend paid for the funeral. The sister didn't go to the funeral. But who gets the money from the lawsuit? The sister. Again, everybody should have a will. If for no other reason, appoint an executor, have somebody in charge. And I can't stress that enough. And we'll have some questions, that we'll answer later. But everybody should have a will. I'll give another story about two sisters. They live in Queens. They live in the family house. It's the house they both grew up in. It's the house they're both living in now. One sister married. She left the family home. The other sister took care of the parents. When they passed away, they gave her the house. Fairly common plan. The married sister, her husband died, and she moved back into the family house. So both sisters now are living in the same house for more than a few years. It's the house they both grew up in. It's the house they're both living in now. If you asked either one of them, whose house is it, they would say, it's our house. It's almost by accident it happens to be in one sister's name. These two sisters have a half-brother. He went to California 40 years ago. Very little contact. He sends a Christmas card. That's about it. Now, the woman whose name the house is, she dies. She has no will. Who owns the house? Well, half goes to the half-brother in California. Half goes to the sister that lives with her. Half-brother is the same as a full brother or sister under New York state law. So, again, you got to do your planning. Now, we're going to say in this case, same fact pattern. The sister owns the house. She goes to a general practice lawyer. She says, I want to do a will. I want to protect my sister. I want to leave everything to my sister, including my house. So they do that. Nothing else is talked about. Nothing else is discussed. The sister who owns the house, again, she dies. The deed to the house is in her name alone when she dies. So we got to go through court. Now, the sister who has inherited the house, she goes to a lawyer with a copy of the will, death certificate, and deed. I want to sell my sister's house. The lawyer gets the family tree. He finds out about the half-brother in California. And he says, well, before we can probate the will, let's try to get the consent of your brother in California. What's the address on the last Christmas card he sent? And a letter goes out in the mail, and there's no response. And so the lawyer starts getting on the internet, and he gets a phone number that matches the address. He gives it a call. Woman answers the phone. She says, yeah, I remember him. I think he died a few months ago. Check with Social Security death records. Yes, he died. Write to California to get a copy of the death certificate. Maybe we're home free. No relatives to contact. But the death certificate comes back, and it says informant, daughter. Who's she? Well, under New York state law, she's a next of kin. The will cannot be probated unless she either consents to the will, has been officially notified, and given an opportunity to contest the will. So, in this case, the daughter of the half-brother, the niece, has been married, divorced, remarried, moved out of state, and has a very common name. The lawyer tries to find her, but he can't. So he explains this to court, and the court says, before we allow you to probate this will, you're going to have to hire a genealogist to try to find this missing niece. Now, the genealogist is kind of like a private investigator. He goes through death records, census records, probate records. In some states, you can get divorce decrees after somebody dies. And he does find this missing niece. He writes her a letter. But she has a very common name. So he's writing 100 people the same letter. So yes, he found her. He wrote her a letter. But what does she care that her aunt in New York died that she never met? So she throws the letter away. So the genealogist has to keep on looking. How long does the genealogist have to keep on looking? Until the judge is satisfied that everything reasonably done has been done to try to find the missing niece. So after maybe, and this could take years, after a couple of years, the genealogist writes his report. I can't find the missing niece. This is what I've done to try to find the missing niece. All right. The judge says, well, this is a reputable genealogist. We'll accept his report. Does the woman get probate? Can she sell the house without any problem? No. The court orders publication. If you've seen those ads, usually in the back of a local newspaper like the Brooklyn Eagle, citation, surrogates court, those are ads looking for missing relatives. Those ads cost money. Those ads take time. 3 to 6 months later, Those ads run their course. Papers are filed with the surrogate's court. Does a woman get probate? Can she sell the house? No. The court may appoint a lawyer to protect the interest of the missing niece. The court-appointed lawyer wants to interview the two witnesses to the will, which is only correct. It's the right thing to do. But the two witnesses to the will are two neighbors who've moved. And they get a letter in the mail now, and they say, hey, we don't want to get involved, which is the wrong time not to get involved. If your neighbor asks you to witness a will, they print up a will off the internet, and they say, hey, will you sign this? You sign that will, you could be dragged into court proceeding years later. You really don't want to get involved. Leave it to a professional. But at the same time, if you've already witnessed a will, you owe a duty to the deceased person to testify because they cannot speak for themselves. Now, eventually, we're going to say in this case, the witness is cajoled, coerced, bribed, but they come into court and testify. The court-appointed attorney writes up his report. I believe this is a good will. The judge approves it, and the will's probated. But how long did this take? I would say conservatively it might take 3 to 4 years. Meanwhile, the sister who's left the house is paying for her own lawyer. She's paying for the genealogist. She's paying for court publication, court filing fees. She's paying maybe for the witnesses to come in. It all adds up. It could easily cost $40,000, $50,000. Meanwhile, she's a prisoner of the house while this is going on for 3 to 4 years. She could get a court order to sell the house, but where is she going to live? And she was kept a prisoner of the house while this was going on, not because her sister didn't care, because her sister didn't get the right advice. Her sister thought, I have a will, that's all I need. A will, if you have missing relatives, takes forever to get through probate. Remember, all your relatives have to be officially notified with a will. You can avoid that by avoiding probate. You want to avoid probate if somebody's going to contest your will, Jack. You want to avoid probate if you have missing relatives. You want to avoid probate if your next of kin is incompetent. So let's say we have a husband and wife. Husband's diagnosed with Alzheimer's. When husband's first diagnosed with Alzheimer's, he says to himself, you know, I worked very hard to pay off the mortgage on my house. I may have to go to a nursing home in a few years. I don't want part of my house to go to a nursing home. So he and his wife come up with a plan. They deed the house to the wife. Wife does a will leaving the house to their 2 children. And the first part of the plan is good, but again, they drop the ball. They get the wrong advice. A few years later, husband goes to a nursing home. A few years after that, he forgets his own name. He can't sign his own name. He can't write his own name anymore because he's forgotten it. Wife dies. People don't always die in the right order. The kids want to sell the house. And that's probably the wrong idea, but they don't live in New York and they don't want a vacant house sitting around in New York, so they want to sell it. Whatever money they get, they get. So the problem is, again, the deed is in the wife's name alone. They got to go to probate. Probate procedure, the husband has to be notified. Well, court clerk says, where's the husband's here? Does he consent to the will? Well, he's got Alzheimer's, he's in a nursing home. So say, okay, we have to appoint a court-appointed lawyer to protect his interest. The court-appointed lawyer then gets involved and may have a completely different spin on the same fact pattern. Your Honor, my poor client is in a nursing home. He has Alzheimer's. His wife must have tricked him out of signing the deed from husband and wife to wife. Then she dumped him in a nursing home. Then she wrote a will. She didn't leave him anything, leave him out in the cold. I don't like this. I think we should put a claim in against the wife's estate. Now, assuming the husband's been in a nursing home the last 4 to 5 years, where's the money going to go? It's going to pay back to Medicaid or nursing home bills. The husband won't see any of the money. Exactly what he wanted to accomplish was voided because he didn't have a good plan in place. And on top of that, the court-appointed lawyer gets paid a fee. And the interest of the court-appointed lawyer is not going to be the same as the family. And that's one of the reasons you want to avoid probate. You don't want to get involved in the court system if you can avoid it, and you can avoid it if when you pass away, there are no assets in your name alone when you pass away. Now, so that's 3 reasons now. If somebody's going to contest your will, if your next of kin cannot consent to the will because they're not competent, and That could even be a 10-year-old grandchild who might be next of kin who can't consent to the will. Another reason you want to avoid probate: medical bills, nursing home bills. The average cost of a nursing home in the New York City area is about $15,000 a month, $500 a day. So let's say you own a home. You're married, husband passes away, wife owns the house, it's in her name alone, or a co-op. So, you go to a nursing home, social worker says, well, you don't have to worry about it, we're not going to take your house. But then, when you pass away, if let's say the deed to the house is in your name alone when you pass away, you're single, what's going to happen to your house in reference to that unpaid nursing home bill of $15,000 a month? They're going to have a lien on your house. And you could possibly lose the entire house, or at least a good part of it, to medical bills, nursing home bills. When you go through probate, medical providers are very good at looking at probated estates. They have their computer programs. They put a lien against the estate. The executor, the administrator of the estate, cannot finalize, settle the estate until that lien is dealt with in court. And that's why we all want to avoid probate. We don't want our house, our homes, to be sitting ducks for nursing home bills. And forget all of the problems we just talked about. It's the delay. Now, a year ago, if I were doing this seminar, one of the things I would not necessarily talk about it is the courts being closed down. But let's say if somebody died in the middle of March, they had a house with a mortgage and you had to pay the mortgage off each month. Well, to get through the court system's been closed since the end of March, and probably nothing's going to get done for at least 6 months. And so somebody's going to be stuck with a house, paying a mortgage, paying the real estate taxes, not being able to sell the house because the deed is in the decedent's name alone, and we're waiting for the court to give us permission to sell the house. Even in the best of times, we would want to avoid probate to avoid delay. But today, and it could happen again, we want to avoid probate because COVID has delayed the court system and has probably backlogged the court system probably for a couple of years right now. We want to avoid probate. Why do you want your relatives to have to go through court to sell your house? If you have bank accounts, it's very easy to avoid probate. You put somebody else's name on the account. If you have, an annuity, an insurance policy, 401k, IRA, you put beneficiaries on it. You have a brokerage account. You make a TOD, transfer on death. All those designations will avoid probate. There's no court proceeding. I'm not talking about taxes right now, but there's no court proceeding. The asset goes directly to the named beneficiary. Now, if you own a house, it's not quite as simple. Let's say you have a husband and wife, they own a house together. Husband dies, house goes to wife. She doesn't have to go through probate to sell the house if the house is listed husband and wife. She can sell the house with a copy of the death certificate and the deed, and probably tax-free. I'm going to give one example right now. Let's say we have a husband and wife, they own a house together. They paid $50,000 for the house 40 years ago. It's worth $1 million today. Husband dies, wife gets, under ordinary circumstances, wife gets half of the value of when her husband passed away, $500,000 out of the house tax-free. She gets $250,000 out tax-free, assuming it was a residence. And then if she sells within 2 years of her husband's passing, she gets $250,000 tax-free from his estate. So in effect, she can sell the house for $1 million tax-free. So that's why I say ordinarily tax-free. There's no death estate tax between husband and wife, U.S. citizens, whether it's the federal government, New York State, or otherwise. There's no tax between husband and wife, no gift tax, no estate tax, no death tax between husband and wife in New York, federally or otherwise. The problem in this case is going to be if the wife decides to live in the house, to stay in the house for her lifetime, that house is going to be a probate asset. So what does the surviving spouse, what does the wife do in this case? So when she passes away, the deed is not in her name alone when she passes away. Well, when life was simpler, some people would say, I'll just put my son or daughter's name on the deed. But that's not the right way to do it. Too many bad things can happen. You put your son's name on the deed. He dies before you. He's married. Who owns part of your house? Your daughter-in-law. And you may not be crazy about that. And remember, it's almost impossible to completely disinherit a spouse in New York. A wife always has a claim against the estate. So the spouse, his wife, would own part of that house. And you may not be crazy about that, especially when she gets remarried a few years later and she forces the sale of the house because she wants to get what's coming to her. Bad things happen. You put your daughter's name on the deed. She's married. She's married to a businessman. He's taking expenses and deductions off his tax return he shouldn't be taking. They file a joint return. Your daughter signs the return with him. The IRS audits the return. The IRS puts a lien on their assets. The IRS puts a lien on your house because you put your daughter's name on the deed. You can't sell or mortgage your house until that IRS lien is satisfied. And don't think that your daughter can just deed the house back to you and there's no problem. The IRS agent in charge of the file can get a computer, find every real estate transaction that involved your daughter's name for the last 50 years. There is no privacy in real estate deals in New York. So he can check, see that your daughter transferred the house back to you. He can still attach a lien to the house. You can't sell or mortgage that house while that lien's in place. Your son's single. He's a very reliable man. He's not married. He gets a job where he gets a paycheck each week. He's not going to get in trouble with the IRS. He's driving one day. It's a rainstorm, heavy rainstorm. He hits the brakes. His foot hits the brakes. Hits the back of a school bus. Children playing in the back of the bus. They shouldn't have been playing, but they're not responsible. They're children. Your son's responsible. He hit the back of the bus. Those children have a lawsuit against your son. Those children have a judgment against your son because insurance doesn't cover everything. Those children have a judgment against your house. You can't sell or mortgage your house while that judgment's in play. Judgments can be renewed for up to 20 years. That's a long, long time. And every example I just gave, believe me, I'm not using my imagination. I am using my memory. I've seen it all happen. You got to be careful. I'll give you a story that hit the Daily News a few years back. The headline in the Daily News was, "Hit the Bricks, Granny." Here's the story behind the headlines. 90-some-odd-year-old woman in Carroll Gardens, Queens, owns a house. She's 90-some-odd years old. Well, I'm not going to live much longer. I'll put the house in my daughter's name, make it easy for her. Daughter's in her 70s. Daughter dies. Daughter leaves everything to her son. She's got a simple will. I leave everything to my son. The son now inherits the house. Does he want to wait for his 95-year-old grandmother to die before he sells this $2 million house in Carroll Gardens, Brooklyn? No. He's got to do what he's got to do. He's got to evict the old lady. Headline, "Hit the Bricks, Granny." Bad things happen when you just start putting somebody else's name on your deed. You just don't do it that way. What do? The most effective way to avoid real estate is through a trust agreement. What's a trust agreement? Basically, this simplified form, it's a family contract. It's mom, dad's house as long as they're alive. After they're gone, it passes to the next generation. There's no estate tax in New York under $5,850,000, indexed for inflation. There's no federal estate death tax under $12 million. So 95% of the time, the children can sell the house tax-free through a trust agreement. What about capital gains? Parents paid $50,000 for the house. It's worth $1 million on date of death. Capital gains are wiped out on assets in a trust agreement. It's called a stepped-up basis. Assets step up to their date of death value. So if you paid $50,000 for your house, your children sell the house for $1 million. After you're gone through the trust agreement, they put $1 million in the pocket after the closing costs. There's no tax. Taxes are wiped out by death. Now, if you leave your house through your will, taxes can be wiped out by death. But if you leave your house through your will, it's going to go through probate, and maybe the combination of legal fees, medical bills, bureaucracy is going to be worse than the taxes. You want to avoid probate. You want to get the house out tax-free. You put your house in a trust. And most of the time, we can save your house from nursing home bills, medical bills. We put your house in a trust now. It's protected from medical bills immediately. Your house goes out tax-free. What do I mean by tax-free? There's no death tax in New York under $5,850,000. The federal amount is virtually $12 million. So in other words, if your children sell your house, the estate is worth less than $6 million, they do not pay any taxes. estate taxes. There's no death tax under $5,850,000 in New York State. Capital gains are wiped out by death. You paid $50,000 for your house 30 years ago. They sell the house for $1 million. They do not pay capital gains taxes. Capital gains taxes are wiped out on assets that pass through the trust. Now, if your assets pass through your will, capital gains taxes are wiped out by death. But you have to go through probate, which means the combination of legal fees, medical expenses may be worse than the taxes. The only effective way and the best way to transfer the house to your children is through a trust agreement. It's your house as long as you're alive. After you're gone, it goes straight to them. It works like an insurance policy. The beneficiaries on an insurance policy can cash in the policy a few days after you're gone without going to court. The beneficiaries on a trust agreement can sell your house a few days after you're gone with a death certificate. And that is extremely important in today's world. People that had their house in a trust agreement can go to closing within a few days now without going through court, which with COVID right now and the courts closed for months and months, that is a tremendous advantage, which I didn't even think about when I started doing this seminar years ago. Now, ordinarily, we can protect your house from medical bills and nursing home bills. There is no look-back period to put your house in a trust and protect it from medical bills. Now, I'm going to talk about this on October 1st, 2020. The law is going to change as far as home care Medicaid, and we'll talk about that in a few minutes. But your house can be protected from medical bills not covered by insurance immediately to fully protected from nursing home bills. It's a 5-year look-back period, which means if you apply for medical assistance Medicaid to pay for a nursing home bill, you have to document all your transactions for 5 years prior to your application for benefits. And we'll talk about that a little later. But if you own a house, you want to get it to your children without going through court, protecting it from medical bills, nursing home bills, get it out to them tax-free, then we look at a trust agreement. There's no one size that fits all, but that fits a lot of people. So if you want to talk about a trust agreement in our office, you own a house, that's what I'm going to recommend to you. So you can call for an appointment anytime. Again, I know a lot of people out there saying, well, I'm not sure what a trust agreement again. It's a writing. We prepare the writing. It says, again, it's your asset as long as you're alive. After you're gone, ordinarily it goes to the next generation. Could it go to a younger brother or sister? Yes. Significant other? Certainly. It's just from my examples, I'm using the trust agreement from parents to children because 90% of the trust agreements we do are parents to children. But again, if you want to put in your mind, my significant other, my younger brother or sister, my friend, you can do that. I'm just going to use the terminology parents to children because 90% of the trust agreements we do are from parents to children. And you know, a trust agreement doesn't necessarily have to be for only real estate. It's the most effective way to avoid probate on real estate, but there are also things why you can do it for, let's say, for bank accounts or stocks. Let's say we got Mr. Smith. Mr. Smith sold his house a couple of years ago for $1 million. He's got $1 million in the bank. And he's got 3 children. And he goes to the bank to open up an account. And the banker says, well, you shouldn't have $1 million in your name alone. You should put somebody else's name on the account. He says, well, I got a son in Texas. I got a daughter in Florida. I got a daughter here in New York. I'll put the accounts joint with my daughter here in New York. And that's fine and good. I have a will. I leave everything I own in 3 equal shares. Mr. Smith dies. Daughter goes to the bank, closes out all the bank accounts. Brother and sister come up for the funeral. How much money did Dad leave? None of your business. All the accounts were with me. He wanted me to have all the accounts. What about the will? The will said 3 equal shares. The will is a very limited document. The will only covers assets in your name alone. For better or worse, the will does not cover assets that are joint in trust for someone else. So obviously there we have a problem. We have a trust agreement. We put the bank accounts in trust with the daughter. She signs an agreement that everything in the trust will be divided in 3 equal shares. And we solve that problem. The same thing. Sometimes people leave assets to children who are not old enough to really receive it. You know, this happens all the time. Somebody has an insurance policy. They name their son as beneficiary. What if something happens to the son? Well, I'll leave it to my granddaughter, 10 years old. Son dies. Granddaughter inherits a $100,000 insurance policy at, let's say, the age of 10, 11, 12. That's not a good thing. One, she can't legally sign to close out the account. Two, some taxes are going to be paid on the interest on the account. And three, she gets the account on her 18th birthday, which is not necessarily good. With a trust agreement, you can say, I leave something to my grandchildren. They can receive it when they turn 25 years of age. A trust agreement, in a way, is a way to keep control after you're gone. So I know people get confused by the terminology of a trust agreement. Come in, we'll talk it over, we'll focus on your family situations, and then try to take it from there. When we're setting up a trust agreement, we're talking in our office, you know, a lot of people say, what's the best type of agreement for me? And that's something we have to talk about. There's no one right answer ahead of time. And one thing I'd like you to keep in mind, don't get too tied up in what we call a trust. The name of the trust is not important. It's what do we want to accomplish? What do we want to accomplish through the trust agreement? That is the important thing. A trust agreement is flexible. It can say pretty much whatever we want it to say. Now, of course, 90% of the trust agreements say I leave the house to my 2 children in 2 equal shares. If something happens to my son, his share of the house passes to my grandchildren, his children, not to his wife. And you know, the trust was established 1,000 years ago in the Middle Ages to keep assets within the family line. We do the same thing today to keep in-laws out. But does the trust agreement have to say I leave it to my son and my daughter in 2 equal shares? No. You can have variations. Let's say your daughter's moved into the family house and she's taking care of you. And part of you wants to leave the house to her, but you're saying, also part of you say, well, that's not fair to my son. He doesn't do as much for me, but he's still a good guy. So maybe you compromise and say, my daughter has a right to live in the house as long as she wants after I'm gone. But when she sells the house, half of the sales price goes to her son, my son, half the sales price she keeps. And of course, every good plan has a what if. Every good plan has a what if. You know, and can you say, I leave my son's share in trust for him for his lifetime, and then after he's gone, it goes to my grandchildren? Yeah, you can do that. Now, why would you do that? Maybe you don't, maybe your son's in a second marriage. You don't trust his wife. And you want to keep assets tied up for his lifetime so it goes to your grandchildren, not his second wife. If you ask me, can I do this in a trust? Can I do that in a trust? The answer is yes. It's a very flexible document. We can do almost anything in a trust. Can you say I don't want my house to be sold until my dog dies because I don't want my dog to have to look for a new place to live? Yes. There was a case in Florida, $4 million mansion, and this is in Florida, $4 million mansion. House could not be sold until the dog died. 6 staff members were kept on salary to keep the dog into the lifestyle to which the dog had become accustomed. So again, if you ask me, can I do this in a trust? Can I do that in a trust? The answer is yes. Now, one of the main questions people come in, well, I've read about revocable trusts and I read about an irrevocable trust. Now, I can't change an irrevocable trust, so I don't want that, do I? In a lot of cases, you do. You do want an irrevocable trust. Why? Because an irrevocable trust protects the assets from medical bills immediately. They start the look-back period for nursing homes. Now, again, if you apply for nursing home Medicaid, medical assistance to pay for a nursing home bill, you have to document all your transactions for 5 years prior to your application for benefits. So for the sake of argument, you put your assets in a trust in August. September is month number 1 on the 5-year clock. You're always better off with a shorter clock. You're not worse off because it's not as if you go 4 years and 11 months, you stay out of a nursing home, then you go into a nursing home, you lose everything, you pay for 1 month and you're home clear. And people ask me all the time, well, I'm not going to live 5 years, so it's not worth it for me, is it? Well, you can pass away whenever you want. The assets go out tax-free without having to go to court, and your children can receive the assets the day after you're gone with a death certificate on an irrevocable trust. Now, what scares people about irrevocable is the word irrevocable. In New York, we're very lucky. An irrevocable trust can be changed under certain circumstances. So we can have a provision in the trust. We can change the beneficiaries of the trust among our children, grandchildren, charities. So you can change an irrevocable trust. You can change the beneficiaries of an irrevocable trust in New York. You can fire the trustee. Your son is the trustee. You don't get along with him. Something happens. He gets divorced, remarried. You can't stand the second wife. You don't want him to be in charge anymore. You can change the trustee of an irrevocable trust in New York. So one thing keep in mind, you can change an irrevocable trust. But you have to have a fiction. Another person always has to be the trustee. Your son, your daughter, a combination of your children, trusted nephew or niece, somebody else has to be the trustee. But you can fire that trustee and replace him with another family member. And for the most part, 90–95% of the time, we never change an irrevocable trust. You leave the house to your 2 kids, you're not going to change that. Yes, things happen. Maybe one of the children passes away and you want to make a change. Maybe somebody gets in trouble with bankruptcy or a lawsuit or something like that. You want to make a change. And you can make a change with an irrevocable trust. Now, you're saying, well, that's okay. But what does that irrevocable trust do for me? Again, it protects your assets from medical bills immediately. In New York, starting October 1st, we're going to have a 30-month look-back period for home care Medicaid. Prior to October 1st, if you put your assets in an irrevocable trust, and that still applies to somebody who sees this, this video immediately, if you put your assets in an irrevocable trust before October 1st, it's protected from home care Medicaid. So if somebody has a trust that you set up years ago, you put your assets in there, those assets are protected. You can apply for home care Medicaid as far as those assets are concerned immediately. If you put your assets in a trust, irrevocable, before September 30th, 2020, you can apply for home care Medicaid on October 1st. If you put your assets in an irrevocable trust after October 1st, there's going to be a 30-month look-back period, which basically means it's going to take 30 months to fully protect your assets. Now, there's always something we can do, and I'll talk about that later, but I'm just standing the framework. You do an irrevocable trust to protect your assets from medical bills, nursing home bills, to get in a position where you can apply for home care Medicaid. Now, 90% of the time, if the parents and the children can get along, it doesn't matter whether trust is revocable or irrevocable. Now, why would you want to do a revocable trust? Well, let's say you don't have family members you can trust, or even if you trust them, you don't have any children, you have nephews and nieces, and you're not sure you want to be in partnership with one of your nephews and nieces, so you do a revocable trust. And you have 10 nephews and nieces, you can say in the trust it goes to each one of my 10 nephews and nieces. You don't have to go around with bank accounts trying to balance them out, trying to keep everything equal. The trust agreement says everything gets divided in equal shares. A revocable trust will avoid probate. We'll get the assets out tax-free. We don't have to go through court. So it's a very good tool for some people. And of course, for those people who have long-term care insurance, nursing home insurance, why tie up your assets in an irrevocable trust? We can do a revocable trust, avoid probate, and protect those assets from ordinary medical bills, and of course get them out tax-free. Whether you want to do a revocable trust or an irrevocable trust, that's something we talk about and go over. And that's why you may want to schedule an appointment with us, have an initial consultation, and talk it out. There's no one right answer for everybody. People say, what's best for me? Depends on your family circumstances. But if you have children you can trust and you can get along with them, I'd recommend an irrevocable trust. One of the main reasons we started doing these seminars is to explain some of the rules as far as nursing home Medicaid. And there's a lot of confusion. And even after the change in the rules October 1st, these rules still apply. So let's say we have a husband and wife. Husband has a stroke. And why do I say a stroke? God forbid somebody's diagnosed with cancer. In today's world, there's more than enough time to get your affairs in order. Somebody showing the beginning signs of Alzheimer's, they're warning signals. You can get the proper documents signed. It's the stroke that hits like the sudden bolt of lightning and throws the family into disarray. So husband and wife. Husband has a major stroke. Has to go to a nursing home. The couple has a $1 million house, $900,000 in the husband's brokerage account, a couple of $100,000 in husband's IRA, 401k, a couple of $100,000 in the wife's 401k IRA. Now, the cost of a nursing home is $15,000 a month. The husband has to go to a nursing home in early September. Does the wife have to take $15,000 out of the bank each month to pay for her husband's nursing home bill? Well, right now the answer is no. If the husband can transfer virtually all of his assets to his wife's name on or before the last day of the month, we're taping this in August, so for the sake of argument, the husband can get all the assets transferred over to his wife's name on or before August 31st, he can apply for nursing home Medicaid on September 1st, the first day of the month following the transfer. So let's say he did this he got sick in January. If he could transfer all his assets in January, he could apply for nursing home Medicaid on February 1st, the first day of the month following the transfer. What about the 5-year look-back period? Well, again, as we mentioned, if you apply for nursing home Medicaid, you have to document all your transactions for 5 years prior to your application for benefits. But there are certain transactions which are exempt from the look-back period under nursing home Medicaid. And one major one is transfers between spouses. Husband transfers everything to wife. Wife signs spousal refusal. Husband gets Medicaid to pay for his nursing home bill. Now, what if the husband is not mentally competent as a result of the stroke? Well, the wife can go to the bank. She can take money out of the bank in a joint bank account. But she can't switch stock certificates, even if they're husband and wife, from husband to wife without her husband's signature. She can't switch the deed of the house from husband and wife to wife without her husband's signature. So what does she do? Well, if the husband planned in advance, and of course that's the big if, and that's what we're talking about today, planning in advance. If the husband planned in advance, if he signed a power of attorney allowing his wife to transfer the assets from husband and wife to wife, she can do that. Now, what if he didn't sign the power of attorney? What do we do? Well, then we have to go to court and get permission from the court to transfer the assets from husband and wife to wife. And I can give you 100 horror stories. I'll give you one. 62-year-old man had a massive stroke, had to go to a nursing home, didn't have a power of attorney, wasn't mentally competent. His wife had to get court permission to transfer the stocks in his name alone from husband to wife. There were no legal problems. But it took the court, and today it would take longer, it took the courts 9 months to approve the transfer of assets from husband and wife to wife. At the time, the wife was paying $11,000 a month to the nursing home. This was a few years ago. So it took the judge 9 months to sign the order. She had to pay 9 times 11, $99,000 to the nursing home. But they had insult to injury. The judge signed the order 3 days after her husband died. So the aggravation of going to court didn't even do her any good. If you want to protect your family, think about a power of attorney. Now, another question comes up. If you give a power of attorney to the wrong person, they can wipe you out, they can steal you blind. But if you're married, you trust your spouse, you want to protect your spouse, I strongly recommend you think about a power of attorney. And if you have a son or daughter you implicitly trust, put them on it. Because you got to ask yourself this question: who do I trust more, my family or the court system? And I hope it's your family. At the same time, be careful. There are people wandering around trying to get powers of attorney that may be out to steal your assets. You do have to be careful. But if you're married, you trust your spouse, I strongly recommend you think about doing a power of attorney, because you could leave your spouse with a big problem if you don't plan in advance. So as I mentioned, transfers between spouses are exempt. Husband transfers all of his assets to his wife's name before the end of the month. The first day of the month following the transfer, he can apply for Medicaid. Now, the spouse should act pretty quickly to protect her assets from nursing home bills and do an irrevocable trust to protect her assets. And, that's another question as far as planning. But the wife in that case should protect her assets from lawsuits from the city suing her or the county suing her for support. She should put those assets in an irrevocable trust as soon as possible, assuming she has children she can work with and trust. Transfers between spouses are exempt from penalty under the 5-year look-back period. And the same thing is going to apply when we have a 30-month penalty for home care. Transfers between spouses are exempt. Transfers to a disabled child are exempt from penalty under the 5-year look-back period. So let's say we have a disabled child. Transfers to that disabled child or in trust for that disabled child are exempt from penalty. And like disability, what's disability? A lot of people are confused on that. If you can't work full-time, we have a doctor saying you're disabled, you're disabled. So what's a child? Anybody is a child. If your parent is alive, you are a child. One time we had a 99-year-old woman. She was going to a nursing home. She had a 75-year-old daughter who had some medical problems. A lot of people 75 years of age do. But we were able to get a letter from her doctor. She had retired, We got a letter from her doctor saying she was disabled, she couldn't work on full time. Put that letter into Medicaid. We got the daughter certified as disabled for Medicaid purposes. Mom was able to transfer all the assets to daughter's name, save those assets from nursing home bills. Transfers to a disabled child are exempt. If you collect Social Security Disability, SSI, that's a slam dunk, you're disabled. If you collect SSI, we probably want to put the assets in a supplemental needs trust to protect it from nursing home bills. But transfers to a disabled child are exempt. If your child is under 21, transfers to a child under 21 are exempt. And, you know, again, people get confused. If you're in a crisis situation, get the right advice. I can give you examples, like daughter comes into one of our offices and dad's going to a nursing home and he's got 4 kids. I say, any of your brothers or sisters disabled? No, none of them are disabled. Well, what does your brother do for a living? Oh, he's a fireman. He went out on disability. He had some bad knees. That's a disabled child. Let's look at the exceptions if something comes up. I can't tell you how many times I've had people pay hundreds of thousands of dollars of bills to nursing home bills. Meanwhile, there's a child who's disabled. We're able to use that exemption to save those assets from nursing home bills. Transfers to a disabled child are exempt. Transfer of a homestead. Now, homestead could be a co-op, condo, or house. But transfer of a homestead to a brother or sister who lives in the same house with another brother or sister for 1 or more years can be an exempt transfer. So let's say we're talking about 2 sisters who live together. One sister had a stroke. She's going to a nursing home, assuming she signed a good power of attorney. The sister who has the power of attorney could put the house in a trust, protect that house from nursing home bills, and avoid probate. If you go back to one of our segments, we talked about 2 sisters living together where probate took years. We can avoid that in that situation. Sister's in a nursing home. She has a good power of attorney. We can put the house in a trust, avoid probate on that house, and save her from the one sister's nursing home bills. If we have a son or daughter who's living in the same house with a parent for 2 or more years and takes care of the parent, and that's very liberally construed, we put that asset, we put that house in a trust, we protect that house, no matter how we word the trust, we protect that house from medical bills, nursing home bills. Yes, there's a 5-year look-back period, but if we can show the child lived in the house for more than 2 years with the parent, we protect that house from medical bills, nursing home bills immediately. It's exempt. It's an exempt transfer. It's exempt from penalty under the 5-year look-back period. There are 4 exempt transfers in New York. Transfers to a spouse, transfers to a disabled child, transfer of a homestead, it could be co-op, condo, house, to a sibling, brother or sister, lives in the same property 1 or more years, transfer to a son or daughter who's been taking care of a parent for 2 or more years. If you're in a crisis situation, get the right advice. Remember, somebody's going to a nursing home, somebody needs home care Medicaid, there are 4 exempt transfers. Transfers between spouses, transfers to a disabled child of any type of asset, transfer of a homestead, brother or sister living in the same property 1 or more years, son or daughter living in the same property with parent for 2 or more years. Don't ask me why it's 2 years for children, 1 year for brother or sister. That's the way the law is written. I'm going to give an example of another Mrs. Smith. This Mrs. Smith is a widow. Husband died a few months ago. She's got about $150,000 in the bank. That's her total estate, her total assets. She doesn't have any children. She has 2 nieces involved with her care. Her niece is coming with a plan. The social worker told them, well, your aunt's going to a nursing home. She's got $150,000. She has to turn the entire $150,000 over to the nursing home. There's nothing you can do because there's a 5-year look-back period. Is that true? No. We can always spend money. So in this case, the first thing we're going to do is prepay a funeral. We're going to say, and I'm going to use even numbers, $10,000. We're going to pay the funeral home $10,000, prepay the funeral. Now, why do we do that? Because that money doesn't go to a nursing home, and then when the aunt dies, the nieces don't have to worry about it. Could you make it a $15,000 funeral? Yes. Could you make it a $20,000 funeral? Yes. I'm just going to use even numbers, $10,000. All right. We have $10,000. Under the Medicaid rules today, you're allowed to keep $15,000. The actual number is $15,750. So you can keep about $10,000 for the funeral, $15,000 you're allowed to keep. That's $25,000. You can buy a car. Now, why do you want to buy a car? Because You can buy a car and give it away. It's an exempt resource. So let's say we buy a $50,000 car, give it away to the nieces later. That asset is protected. So in this case, we've taken care of about $75,000 in assets. We have a remaining $75,000 left. Well, under New York state law, we can still make gifts of roughly half the assets. So we can give half the assets away to the nieces, use the other half to pay for nursing home bills, along with Social Security and pension, and we make things even out. But in this case, we can save way more than 2/3 of the assets by giving gifts that are allowed. If somebody were going to a nursing home tomorrow, they had $1 million, we'd do the same thing. It's never too late to do something. And of course, in this case, if Mrs. Smith owned a house and the house was in a trust for more than 5 years, we could take any amount of money and spend it on improving the house. So we can always do something. Remember, it's never too late to do something. We can always do something, as long as the person's competent or we have a good power of attorney. And again, the power of attorney I'm talking about is not a form you get off the internet. It's not a form you're going to get from LegalZoom.com. To accomplish everything that we've been talking about today, we have to have a specially drafted power of attorney. And in my experience, 75–80% of the power of attorneys, even drafted by general practice lawyers, do not cut it. You need a specially drafted power of attorney to do everything that we've been talking about today. So be careful. Again, in a crisis situation, always get the right advice. We're now going to start talking about estate, gift, death taxes. Remember, there's no gift, estate, death tax between husband and wife, U.S. citizens. Husband give his wife $100 million. Wife can give her husband $100 million. We do not have to file a return. We do not have to pay a tax. Now, how much can you give away legally today as far as the IRS is concerned? Well, some people think it's $15,000. If you give away more than $15,000 in a calendar year to one person, you're obligated to file a gift tax return. So if we have a husband and wife and they have 2 children and the 2 children are married, the husband gives $15,000 to his son, $15,000 to his daughter, $15,000 to his son-in-law, $15,000 to his daughter-in-law. He does not have to file a return. The wife can do the same thing. Coming the next calendar year, January 1st, they can do the same thing and not have to file gift tax returns. Gift tax returns are not a problem for the middle class. Now, here's the kicker. There is no gift tax due until your lifetime gifts, as far as the federal government is concerned, exceeds $12 million. There's no gift tax due. And that's $12 million for husband, $12 million for wife. Why do you have to file a return? The government wants to keep track of money. Where is money going? That's why you should file a return if you give away more than $15,000 in a calendar year from one person to one person. Remember, husband and wife can give $30,000 to one person. So gift taxes, again, are not a problem for the middle class. Now, where some people get in trouble, they confuse the IRS rules for the Medicaid rules. So let's say we have an elderly couple. They're in their 90s. They've got $100,000 in the bank. They have other assets. They have a house. And so in their will, it says, I leave $10,000 to each one of our 10 grandchildren. And they say to themselves, why do our grandchildren have to wait for us to die to get that $10,000 gift from us? We spoke to our accountant. He says, we can take $100,000 out of the bank and give $10,000 to each one of our 10 grandchildren. They can enjoy the money now. We don't have to file a gift tax return. There's no problem with the IRS. Absolutely true. They write out 10 checks. Grandchildren say thank you. The money's spent before the check's clear. Husband has a stroke. He has to go to a nursing home. Wife has to pay, well, wife has a $15,000 a month nursing home bill. She wants to apply for Medicaid. Well, Medicaid says, you can't apply for Medicaid. You just made a $100,000 gift a couple of months ago. That's not allowed. But yeah, but it was less than $15,000 per person. That's allowed. No, it's allowed for the IRS, but not for Medicaid. They're 2 separate sets of rules. So what happens? Well, hopefully the grandchildren give the money back, but that might not be possible since, like I said, the checks were spent, the money was spent before the checks cleared. So grandma's in a tough position. She's going to be hit with a 7-month penalty, 8-month penalty for Medicaid because she gave away $100,000. And husband and wife is one person as far as Medicaid is concerned. She has to pay the nursing home bills for 7 months. 7 times 15. 7 times 15 is more than $100,000. She's left in this position. She's going to be sued by a nursing home or Medicaid or both because she got the wrong advice. She got the right advice from her accountant, but they didn't take into account the Medicaid rules. You got to be very careful about making gifts in today's world. You're married, your spouse makes a gift, you may be stuck with that gift for years and years in the future. There's a 5-year look-back period. Put the assets in trust. The grandchildren get the money back or get the money when you pass away. Death, estate taxes. There's a lot of confusion in these areas. Again, there's no death estate tax between husband and wife, both U.S. citizens. If somebody out there is not a U.S. citizen, there are different rules, so give us a call on that. So, you know, and somebody reads in the newspaper, there's no, and I'm using round numbers, there's no death estate tax as far as the federal government is concerned under $12 million. So if somebody dies, they're single or otherwise, if they have less than $12 million, their estate is not subject to inheritance, death, estate tax. Now, where some people get in trouble, let's say in New York State, let's say you have a married couple, they have $6 million in assets, they know there's no tax between husband and wife, they know there's no federal tax under $12 million, and they say, well, we've got $6 million, but we shouldn't have to worry about that too much because New York State doesn't impose a tax until you get to $5,850,000. So why do we need to do some planning? How much can the tax be? Husband dies, leaves everything to wife, there's no tax. Wife then dies, $5,850,000, but she leaves $6 million. So we're $150,000 over. How much do the children have to pay in tax? More than $200,000. That's a sin, that's a crime, but that's the way the tax laws are written in New York. So if you're close to $6 million in assets, you need to do some tax planning. New York State is out to get you. If you're well under $6 million, you don't have to worry about estate, death, gift taxes. You got to worry about saving your assets from a nursing home. In either case, you need to do some planning. You're more than welcome to do the planning with us. You can give us a call at 718-238-6500. 718-238-6500. We do not charge for the first consultation. The initial consultation is free, and then we go from there. There's no one right answer for everybody. Some of you out there have children you can trust. Some of you don't have children. Some of you may have $15, $20, $30 million in assets and need to save on taxes. Some of you may have $50,000 in the bank and you want to save it from a nursing home. In whichever case you are, please feel free to call for a consultation, and we'll go from there.